Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I am going to be your employment lawyer for the next 30 minutes. As you can see, I am employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee side employment law firm. A couple items of housekeeping before we get started. If you need to reach us, you can do so at employmentlawyer.ca, as you can see on the screen, help@employmentlawyer.ca, and of course, 1-855-821-5900. Okay, let's get to it. We've got some questions rolling in. Well, we've got a few questions coming in, but please send all of your questions. I'll try to get through all of them, but sometimes a lot of them come right in at the end, and I'm not able to get to all of them, and I'd like to answer all of your great questions today if I can. Okay, great. We've got a question from, that name's unique. I'm not going to identify it. I'll just call this person I. So can the employer change the employee pay type from salary to hourly? Does the employee need to agree or not a must? Okay, so often when there's a change from salary to hourly, it's actually beneficial to you because it allows you to obtain or to receive overtime pay if you're not a manager. Quite often that I don't know from your question what is the reason for the change. I will say generally, are you incurring a loss from this change? So if your pay is changing, if it's going down, it could be that your employment has been constructively dismissed by the change, but the pay change would have to be non-trivial. So in British Columbia, for example, below 10% of a change, probably not a construct. Sorry, I'll back up here for a second because I didn't explain what a constructive dismissal is. Many of you have heard of constructive dismissal before. It's where the actions of the employer are in effect a termination. So the best way to explain that is to give an example. If your employer comes up to you one day and says, we're reducing your pay by 30%, or we're reducing your hours by 30%, and therefore your total income by 30%, that's a breach of a fundamental term of your employment and is therefore a constructive dismissal. However, nobody should ever claim a constructive dismissal or attempt to effect a constructive dismissal without legal advice. They're too hard, they're too complicated, and if you get it wrong, you in fact quit and you get nothing. Okay, so 100% of the time, if you think you've been constructively dismissed, get legal advice first before you take any action. Okay? Now, in this particular case, if your wage, if your total take-home pay has been reduced by 10% or more, then it is, or if even if it's less than 10%, and there's some other changes like a reduction in your prestige, position, duties, etc. It may be that you've been constructively dismissed, and you should talk to a lawyer. But if not, if it's just a small pay change, where you lose a few dollars, you gain a few dollars, and there isn't a tangible loss that you're incurring, then yes, they can do that. But let me know if you have incurred some sort of tangible loss. Chime back in with an update to your question. I'll try to get to it later in the show. Question from Dennis. Why do you have to exhaust sick hours, vacation, and banked OT first before taking EI when you're on leave for cancer and getting surgery? I don't think you have to. I talked to Service Canada about that, though. I am an employment lawyer, but I don't deal with EI head on in terms of the policy rationale behind why Service Canada, who administers EI, I don't know why they make decisions on sort of a granular level about certain components, but I would think that you wouldn't. To go on medical EI, you shouldn't have to, like, EI shouldn't be payer of last resort, I don't think. And you shouldn't have to exhaust your sick hours, etc. I did deal with this once before I was a lawyer when I used to run call centers for major technology corporations. I had an employee who was involved in a serious car accident, and EI, Service Canada made him do the same thing, exhaust his vacation pay before they give him medical EI. And I ended up having to call Service Canada and spending a number of hours trying to get that corrected. I eventually did. They issued a correction. But I have encountered this before. I don't think it's correct, but certainly maybe Service Canada does do that. Your remedy there, Dennis, is to talk to Service Canada. They're a government entity, and they make their various decisions. You can appeal their decisions to the tribunal if you need to. But I don't know how much you're out and what that's worth to you. But I think your first line of attack here is just pick up the phone, call Service Canada. I've heard from some of my clients that the wait time to get to Service Canada is substantial, but give them a call and see what they have to say, and maybe they can correct that for you. And if they say no, ask them to point to the applicable regulations or policy comment on what they're saying or why they're forcing you to take your sick hours, vacation, and banked OT before you get your medical EI. And if they can't, ask them or concurrently ask them for, if you want to appeal the decision, what is the avenue for doing so? Question from CS. Is there an obligation for an employer to ensure retaliation is not occurring? If so, what are the legal definitions of retaliation, and can someone file suit while still being employed there? Well, let me take the last one first. So, yes, you can file an action against your employer while you're still working there. I don't recommend it. I think that's not going to be conducive for a pleasant work environment. I think that by the time you sue your employer, generally, in almost all cases, it's because you either have been terminated, constructively dismissed, or otherwise the relationship, you have some sort of cause of action ending the relationship. It's not really a good situation for you to be filing action against your employer while you still work there. Okay. Now, retaliation on its own, though, isn't a cause of action. So what I mean by cause of action is, you don't have the right to sue because of retaliation. Now, there are, in and of itself, there are lots of things that can ground, your cause of action to sue your employer. If you've been constructively dismissed, as I talked about earlier in this broadcast, if you've been terminated and not provided the correct amount of severance or notice. So it depends on the details of what you're talking about. I will say that if you've got a wrongful dismissal lawsuit and there was clear bona fide retaliation, that can assist you in obtaining extra compensatory damages, such as, well, I shouldn't call them compensatory damages, but punitive damages, or if you suffered some sort of mental distress from the retaliation, perhaps aggravated damages as well could be available to you. Those are both hard to get and tend to be smaller, but certainly in Ontario, the trend has been substantially upward for those, and even BC, there's been a little bit of trend in an upward direction. So you can get that. Also, and this is different in every province, but if there's been a violation of your entitlements under the Workers' Compensation Act in BC, you may have a prohibited action. And if there's a retaliation when you've reported something like a safety violation, then certainly you could have a prohibited action for that retaliation. So there is a ground for a remedy on retaliation alone in a very specific, narrow context. But you'd have to, I don't know about the other provincial jurisdictions, and certainly you'd want to talk to an employment lawyer about that if you are in fact in BC. If you need to get a hold of us to do that, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. But just to summarize my answer there, generally no, retaliation is not a ground of a cause of action. It can, however, leading you to sue, it can, however, we'll say beef up your lawsuit to allow, it not only if there was bona fide retaliation, it makes you more sympathetic in the eyes of the court, but but also allows you to potentially access additional damages beyond your standard wrongful dismissal compensation damages. Okay. S asks, I went to do my taxes and my accountant noticed that the company never took all the proper amount of taxes off of all of my checks. I even asked for more extra to be taken off my TD1. Is it up to them to fix the issue, or am I at a loss? I'm not a tax lawyer, so I can't really answer that question. But I will say, when I look at that, it looks like so your employer, the government has fixed it where they can reach into your paycheck before you get it, direct through the employer, take money out and remit it and have it remitted to the government. And if the employer didn't remit the correct amount, it just means that you didn't pay enough taxes. So I don't, it's annoying, but I don't see how that's the employer's loss. But again, I'm not a tax lawyer, so I'm not going to say that is advice of any kind whatsoever. And I don't have your specific information in front of me, but it sounds like you didn't pay enough taxes. So I would work with your accountant to sort that out. But I will say this, because I am not a tax lawyer, you may wish to contact a tax lawyer about that question. Sorry, I didn't have a better answer for you than that one. BB asks, if you have to travel regularly as part of your job, can your employer stop reimbursing you for travel expenses and mileage? You need to look at what your employment contract says. Okay, and I don't know if the Employment Standards Act in your jurisdiction talks about any of that. I've never looked into it. But if your employment contract discusses reimbursement for travel expenses and mileage, then they're in breach of the contract. Now, if your loss is, if you're making $200,000 a year and you're out $3,000, maybe you don't want to pull the plug that much on that. I mean, it wouldn't even be a constructive dismissal. Your resolution there would be amicable. I guess you could bring a lost wages complaint against your employer through the Employment Standards branch in BC, and it's called various different things in different jurisdictions. Again, if you're provincially regulated. Have you discussed this with your employer? And did they tell you why they're stopping doing this? Listen, if it's a substantial amount of money, you have to assess what they're paying you in your job, how long you've been there, do you like it there, goodwill, opportunity, all that stuff, versus what you can get on the open market. If your employer, though, said to you, we're going to pay you travel expenses and mileage, and just stop doing that, you might want to look at the larger relationship and see if that's still a satisfactory one to you, because it's not a good thing that that's happening. I will say, if you've been getting the reimbursement of travel expenses and mileage for years and years and years, they can be potentially, or most likely are, an implied term of your compensation, and the removal of it could ground a constructive dismissal, but it would have to be substantial, or there would have to be other pieces to it, like a demotion, loss of prestige, other parts of your wage being cut, etc. So, you may wish to talk to an employment lawyer about this one. If you can answer some of the questions and points that I brought up just now, later in this broadcast, I'll take a look at it. But you may wish to talk to an employment lawyer. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. Lori asks, can LTD Manulife require me to appeal my CPPD denial? I have applied twice and was denied twice. If their policy does not require me to appeal, can they lessen my payments if I refuse? So that's actually a disability question, and I don't practice disability law. You can join us next for our next disability law, and actually, Laura, you should do that. Our next disability session is on March 19th at 1 p.m., which is 10 p.m. Pacific time, with Martin Willems, who's a partner in the Vancouver office, great lawyer. Or you can also go to mydisabilityquestions.com and ask one of our disability lawyers that question. So the Lori, our firm it's a union of both disability lawyers and employment lawyers, and there's a lot of overlap between the two, but they're substantially different areas. So I would definitely tune in for Martin's broadcast on the 19th and ask that question. Martin has been practicing disability for a very long time, and will definitely be able to answer your question. You could also, because the 19th is 11 days away, you may wish to send that question to, hold on, I'll pull it up on my screen again, mydisabilityquestions.com, so you can try to get an earlier answer. Okay, I is back. Okay, the change will be from salaried to hourly. It'll impact around 30% of the total income for the employee. Does that change is it considered a constructive dismissal? Sorry, I don't know what you mean by total annual income. I'm a little leery of that. So if your actual pay went down by 30%, then yes, it's very possible that's a constructive dismissal. Excuse me. It's very possible that's a constructive dismissal. It's over 10%. I'm not. You kind of want to be over 20 to be 100%, but it's in that range. Particularly if there are other pieces that have been changed as well, then certainly it can be constructive dismissal. Just a couple points about constructive dismissal here. You have to act. Constructive dismissal is it's one of the harsher doctrines in employment law on employees. So it involves usually an employer imposing on you a change to a fundamental term of your employment, like, hey, your pay is going down by 25%, or cutting your hours, or removing you to the other side of the country, or whatever it is. It's an imposition of a change that you don't agree with to a fundamental term of your employment, and you've got 2 to 3 months, at least in BC, but generally 2 months has been accepted, to object to that change. And it's not just an objection, it's effectively ending your own employment. Okay, so you've got to say within, and again, don't ever do this on your own, make sure you do it in coordination with a lawyer, but you've got to say, this is a constructive termination of my employment, and effectively fire yourself, and consider or treat the change by the employer as a constructive dismissal. If you don't do that within 2 months, you're deemed to have accepted 2 months of the change. You're deemed to have accepted it. So you can't come back 6 months later and say, "Oh, you lowered my pay by 13% 6 months ago. That's a constructive dismissal." No, it's not. You've been working under that reduced pay now for 6 months. You've accepted that change. So you've got a short fuse to determine whether or not you're going to end your own employment at your employer. It's a very tough thing, and so, but many times it's something that an employee needs to do. A lot of times with my constructive dismissal clients, they're fed up with the change. Whatever it is, it's usually a pay or an hours cut. Your hours have been cut by 50%, your pay's been cut by 40%, and they're upset that the employer has done this to them, and they're going to move on anyway, and so they claim constructive dismissal on the way out the door. 13% is tough. It's on that line. You could not be successful, but you also very much could be successful. So if anyone I talk to here today, you need to speak to an employment lawyer, and you need to do it right away. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. John asks, is my employer required to provide benefits while I'm off on MTD? Medium-term disability? I haven't heard that expression before. You have to look at your employment contract. Most do. But I haven't. You have to take a look at your employment contract. You don't. I haven't seen it where they've taken it off, and you may wish to ask your employer about that. Even on long-term disability, a lot of times the employers will provide the benefits. So take a look at the four corners of your employment contract and see if it's covered there. Okay, BB's back. Let's just I just need to refresh myself on what BB asked before. A sec. Oh yes, BB was traveling regularly, and his employer stopped reimbursing him for travel expenses and mileage. Okay. Been working there for 6 years, normally receives travel expense amount at a rate per mile. They want to stop this and say it will be our responsibility. That's tough. That's a tough one. I think what I said before then is correct, BB. You've got to look at this holistically. How much are you going to be out by this? I mean, it's aside from the fact that it's upsetting. I get it. But how much are you going to be out? Is this going to be? I don't know how much you travel. If you travel 300 days a year, this could be a substantial amount of money. But are you talking about you're going to be out at the end of the year $3,000? And how much are they paying you? Are they paying you $45,000 a year, or are they paying you $250,000? If it's the latter, maybe you just have to eat this loss. I think that there's a lot. So after you look at that question, there's a larger question to be had here, which is, if your employer is going to do this to you, do you want to continue to work there? And again, if they're paying you a lot of money, then yeah, you do. So you got to think about that. I don't think, unless it's a huge portion of your overall compensation, it's unlikely that a simple removal of a travel account is going to be a constructive dismissal, although it could be. It's not something I'd want to make a bet on. I think if you are, let's just say the relationship for you has soured by this move, then what you may want to do is continue to work there, look around for a new job, and when the right opportunity comes along, then you make a move. It's and maybe you don't want to do any of those things. I don't have the particulars of your job, what it's paying you, etc. But I will say that if a huge part of your job is travel, and they've decided to shift the expense of travel from them to you, it may be that the employment relationship has been damaged to the point where you want to look elsewhere. But these are all questions that are not really legal questions. I think you've got to really think about, what is this loss? Is it significant? How do you feel about the company? And if it makes sense for you to stay, then stay. And if it doesn't, you can look around. But very, very unlikely, unless there's more than that, or you come back in and say that this expense account is 35% of my pay. Very unlikely that you have an action in law for the reduction of the expense account. I is back. Can the employer ask me to sign a document that I agree to reduce my pay and change it from salary to hourly? Yeah, of course they're going to do that. Don't sign it if you think you might not want that. You might not consent to it. So, sorry, we've been talking a lot about constructive dismissal. So, just to refresh, action of the employer, usually a unilateral imposition of a change to a fundamental term of your employment that you reject, is in effect a constructive dismissal. Now, the term has to be fundamental. So that's where we've been talking about, is it a 10% reduction in your pay or a 40% reduction in your pay? Okay, so you've got 2 months from the date of the imposition of the change. So they cut your pay by 35%. You have 2 months to reject it and effectively fire yourself, after which point you're deemed to have accepted it. I mean, it might be 3 months, it might be 2 months, etc. But if you consent to it in writing, okay, so you've got 2 months to try on the change. But if you say, I agree to this change, well, then you've already agreed, right? So no, don't sign that. Now, in BC, I don't know about the rest of the jurisdictions. There are 2 cases on this point, only 2, and that I could find anyway. And one of them says, and it's the older one, says, no. You've got 2 months. So what that you signed right away saying you accepted it. You were under the gun. They gave this to you. The employer gave this to you. You thought you had to sign it, but you still have 2 months to try on the change, and you can in fact still reject it. But another case, a more recent case, says no, you accepted it in writing. You can't go back and change your mind later. Now, as always in legal cases, it's about the details that matter. Context matters, and in this case, the In a later one, the employee was very senior. I believe he was a C-suite employee, vice president, chief operating officer, something like that. So it was very sophisticated and was not just a rank and file employee. And there were reasons along those lines as to why he knew in that case what he was accepting, whereas maybe a rank and file employee might not. But no, if you sign a document saying, yeah, I agree with the reduction of my hours, if you change your mind later, it's going to be much, much harder for your lawyer to get around that, the fact that you signed that. So you need to decide what you want to do. And again, going back to what I said earlier, the pay is a 13% pay cut. Is that a fundamental change? It might be, but I can't tell you it's a slam dunk. I think it could go either way on that one, but that creates risk on both sides. And one thing we haven't talked about, is that even if you get to a constructive termination, so let's just say the court says, yes, this is a termination of your employment, the actions of the employer are termination, you still have to get past your employment contract to get to severance, common law severance. Okay, so if your employment contract contains, so you've been terminated, what does your employment contract say that you get? If it says you get the Employment Standards Act minimums, what's the point of pulling the trigger in your constructive termination if you only get 6 weeks? But if you get 6 months in terms of severance, then that's a different story. So I said it earlier, I'm going to say it again, you 100% need to talk to an employment lawyer. You need to do it right away. Do it next week. Employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Question from Jewel. Can you sue an employer for damages due to a workplace accident? So if you've been injured in a workplace accident in all jurisdictions in Canada, that's been the injuries resulting from workplace accidents, generally speaking, have been taken out of the realm of civil claims. You have to go through your occupational health and work safe legislation. So in BC, for example, you'd have to go through WCB, and they determine what your injuries are, how long they last. They provide you with if you're deemed to have suffered some sort of injury in the workplace, they'll provide you with a wage replacement, wage top up, depending on the situation. And if your injuries are permanent, that can go on forever, or at least until age 65. But no, you can't, generally speaking. Now, if there's gross, I don't even think in the case of gross negligence, but I'm very much open to being wrong on that one. But if it was a deliberate act, like an assault or a sexual assault, I don't know the answer to that question. That would be something that you'd have to direct to a occupational health and work safe lawyer who practices in that area. But generally speaking, you got injured at work, that's something that's handled by an applicable government entity. It is not something you can sue for. I'm going to not say this person's name because it identifies them. I'll call them M. M asks, I have a learning disability, but my manager mistreated me and my coworkers. Okay, so I don't know what your question is, but let's see if I can infer from that. You can't be discriminated against in any jurisdiction in Canada on the basis of disability. Okay, so if your manager mistreated you, let me rephrase that. I don't know what mistreatment means. If your manager discriminated against you on the basis of your disability, okay, then you very likely have a human rights complaint and can bring, if you want, usually it's within 1 year in most jurisdictions in Canada, that's the limitation period, human rights complaint for for either or both of lost wages. In BC, we call them injury to dignity damages. I don't know what they're called in other jurisdictions, but damages for the affront of the discrimination on the basis of your disability. Now, you might not want to bring that claim if you're still working there, or if the mistreatment, as you categorized it, is of a minor nature. Okay, so you may very much want to talk to an employment lawyer to just find out, to assess whether or not you have a claim that you could have a claim, but it's not a claim to very much, to see if you're still working there, to assess really what your potential damages are before you make any decisions about that. Okay, so that's it for questions. Sorry for that last one for M, and for everybody. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, great questions. We got through all of them, which is fantastic. So join us again on Monday Monday at 1:30 p.m. Eastern Time with Chris Justice. Chris Justice will be answering all your questions about all things employment law, so please join us for that. It'll be a great show. I should be back in 2 weeks for my regular time slot, 10:30 Pacific, every second Friday. Thanks for joining us. Have a wonderful and safe weekend.